Chapter 6 of BNS deals with offenses affecting human body. Under that, we have section 100 that talks about culpable homicide. So generally, culpable homicide is a term that we give when a human being kills another human being. The relevance of this term would not be that much important when we just hear about this sentence, but it makes sense when we delve into this provision further. Whoever causes death by an act with intention. Intention is really important here. With intention to cause bodily injury, such bodily injury would turn into causing death. That is, that likely to cause death. Just make a note of this likely keyword here because these are some of the few important deviations that we might find from murder uh, to culpable homicide. So, likely to cause death. Knowledge. So, the person who is causing death has knowledge that such bodily injury would also causes death. Here, culpable homicide, there is always a likeliness, whereas in BNS, there is sufficient knowledge itself, not likeliness. So that predominantly makes the difference between culpable homicide and murder. So here, the person who is causing death has knowledge that such bodily injury would likely to cause death. And the explanation one talks about when a person has already has a disease and just by elevating or accelerating such disease, if any person has been dead, that would in turn amount to culpable homicide as well. One of the research question here is that whether the person causing death is actually known about the fact whether another person to whom he is causing death, whether he has such disease or not, he doesn't know it, the person who is causing it. So that is a big research question here. Explanation 3 deals with when a child is in mother's womb and when a death has been caused of that child, that would not constitute a culpable homicide because uh, that will be construed as a miscarriage of miscarriage, and that would not constitute a culpable homicide. But when a tiny part of that child's body comes out of the mother's womb, even that even in such case, when the child's death has been caused, in such situation, it would be termed as a culpable homicide. So now we're talking about murder, which is dealt under section 101. So generally, culpable homicide is a murder. Let's delve into the provisions. Whoever causes death by doing an act, the person has intention to cause death. The offender knows such bodily injury likely to cause death, right? Here it is not just likely, it is also knowledge. Also, under this provision, there are two different and very important matters that we have to deal with: subjective knowledge and objective knowledge. Here, the offender knows himself that if he is causing some bodily injury, it would likely to cause death. He knows by himself, and he also has knowledge that such bodily injury will cause death. In culpable homicide, it was predominantly likely, and knowledge was there, but in a lesser degree. Not just knowledge, the offender knows that intention would uh, that such bodily injury would likely to cause death, and here the intention to cause bodily injury in the ordinary course Generally, everyone knows whether, like, when the offender inflicts such bodily injury, it would definitely cause death. Like, there is immediate death. So, in ordinary course of nature, everybody knows that it will cause death. When the offender has such knowledge, that is called objective knowledge. Here, not only the offender, but even during ordinary course of nature, generally everyone knows that it will cause death and therefore it would constitute a murder. Knowledge that act is imminently dangerous. Yeah, imminently dangerous. It is a key word here. It was not present in culpable homicide, it is present only in murder. The act that he is doing, the offender, the knowledge that he has, such bodily injury would imminently dangerous and would definitely cause him death. That is eminently dangerous here, and it is present in murder. In all probability, it will cause death, right? And such bodily injury that has caused death should be without any excuse. That is a key word here. There should be no excuse of such causing such bodily injury. Exception to murder. So generally, if there is any offense, when we have some exceptions to that offense, it would generally mean that they do not attract to that particular provision and they would be exempted, and sometimes they might be acquitted. But here in murder, it is not that case. Like, if they do not fall under the murder, they will just go to the culpable homicide, and therefore it was titled as culpable homicide not amounting to murder. They will still be prosecuted for culpable homicide, and there are five exceptions to murder that amounts to culpable homicide is given. First is grave and sudden provocation. We have to consider both grave and sudden be present, not just grave or not just sudden, both should be present. And the offender was deprived of his or her self control, and there was grave plus sudden provocation. There is a relevant case for this game, Nanavati versus State of Maharashtra, and this is a very famous case. So, in this case, the act done by the offender was no sudden reaction, but it was um, there was a graveness there, but there was no sudden. It should be reacted as quickly as he got provoked, the offender. And such provocation, the person who has made the provocation, only his death should have been caused, and not uh, any other's death. If in case such provocation has caused any other person's death other than the person who has in fact provoked, then in such case it should be for sake of mistake or accident. And there are even exception for this grave and sudden provocation, that this culpable homicide not amounting to murder, that is grave and sudden provocation, would not attract in these cases. So offender has not voluntarily provoked. I mean, the person who is dead has not voluntarily sought for provocation, because uh, the person who killed another person is the person who all actually sought for provocation, and the person provoking did not actually start uh, started the provocation, and he did not started voluntarily, the person who is provoking. So here the offender is actually seeking for provocation from the person who is provoking, and thereby causing death of the person who has provoked. Not in public servant on exercise of his duty. So this particular provocation provision will not apply to any public servant who is in exercise of his or her duty. And this grave and sudden provocation would not apply in cases of provocation has been done in exercising of right to private defense. And second exception for murder would be culp- uh, culpable homicide is not a murder if death has been caused in right to private defense. The right to private defense can be in, with regard to person or even property. Here, the prerequisite is private defense has been uh, extended, and the private defense is without any premeditation. Like when it comes to private defense, it is generally uh, coming under. It would definitely go under um, acquittal. It directly goes with regard to acquittal, but when such there is some degree of harm that we can cause even during exercising right to private defense, and such does not extend to causing death of a particular person, and therefore here the right to private defense has been exceeded to the extent that death has been caused. So that will be treated as a culpable homicide and not as a murder, yeah. And such uh, right to private defense should be without any premeditation, and more harm has been caused than necessary, right? So it should also be without any intention. And fourth one is for sake of public justice, a death has been caused by the public servant. In such case, the murder would turn into culpable homicide, but he believed uh, the characteristics should be satisfied here. He believes that it should be lawful and necessary and without ill will. Only then he can claim culpable homicide not amounting to murder, else it wouldn't turn into murder itself. So, fourth exception for murder would be culpable homicide, not murder if committed in sudden fight without premeditation. So, guys, sudden fight is real, and if any people engages in sudden fight and a death has been caused in sudden quarrel or any sort of hustle, a death has been caused in the heat of passion, and here offender shouldn't have been taken undue advantage. He can inflict death only in a proper manner. So he shouldn't have taken unfair advantage over the situation, and he shouldn't have acted in a cruel or unusual manner. Here, due to the sudden fight, a death has been caused. So that would be fourth exception for murder, and it is immaterial whether the offender has caused first assault or the person who has dead has caused the first assault. It is immaterial here. Death has been caused, and the person who is causing death would be charged for culpable homicide and not murder. Here, when death has been caused in sudden fight. Person above 18 years when he consents that you may take my life, or you just kill me. If he consents so, then such person giving consent suffers death, then it would constitute a culpable homicide. But if a consent has been obtained from a person under the age of 18, then it is not a culpable homicide. It is actually a murder, because the person under age of 18 does not have right to give consent to cause his own death. So yeah, these are uh, this is the case law that talks about objective and subjective knowledge that I've concentrated on murder. Visra Singh versus State of Punjab. And punishment for murder is given under section 103 clause 1, that is simply a death penalty, and life imprisonment is given. And section 103 clause 2 deals with mob lynching. So this is a new provision under this Bharatiya Sanhita, Nyaya Sanhita, and the punishment that is provided for this mob lynching would be death, life imprisonment, and fine. Section 105 deals with punishment for culpable homicide not amounting to murder. And if the person has committed a culpable homicide with intention, then such person shall be punished for life imprisonment, 10 years, and fine. And in Bharati Nyaya Sanhita, a minimum of 5 years benchmark has been provided, because in previous situations where judges used to give in fact fine, or uh, for sake for sake of punishing them, they would just give them 1 year or 2 years and give lesser degree of punishment. Here in BNS, it is mandated that when a person is uh, convicted under culpable homicide, they should get at least 5 years of imprisonment. So generally, the maximum punishment that can be provided is life imprisonment and 10 years when such person has intention. So when the person does not have intention but he has knowledge that such bodily injury would likely to cause death, when such person has knowledge and not the intention, in such case such person shall be punished for 10 years of imprisonment with fine. When a murder has been committed, actually this is dealt under section 104. Murder has been uh, done by a life convict. Of course, he is already sentenced to life imprisonment just because he has committed a murder or a culpable homicide, and he's behind the bars, and now he commits another murder, and therefore he gets death penalty now. And in IPC, there was only one punishment for this, only death penalty, but in BNS, another option is also given, that is life imprisonment. Because in Mithu Singh, which is state of Punjab, it was considered that giving solely death penalty without any other provision such as life imprisonment as punishment violates Article 21, and therefore in BNS, to overcome such lacuna, life imprisonment is also given as an option for the judge to convict a person under. Section 102 deals with the doctrine of transferred malice. So, when a death has been caused of a person upon which uh, the intention was not to cause his death, but the death of another person. But eventually, a death has been caused upon a person who, uh, upon whose death it was not intended. Like generally, if I have intention to cause death of a person, he's not being dead here. Apart from that, another person is being subjected to death here. So, so it is a culpable homicide when causing death of a person other than those whose death was intended. So it was not my intention to kill that person. I was having intention, but not to kill that person. Yeah. So section 106 deals with causing death by negligence and rashness. So whoever causes death by doing any rash or negligent act. This includes rash driving, medical negligence, etc. etc. So let's delve into this provision. Here, this shouldn't be a culpable homicide. There should be negligence as well as rashness present, but not the intention and knowledge. If there is intention and knowledge, it will generally will be dealt under culpable homicide and murder. But there is no intention and knowledge, but there is negligence and rashness only. So the punishment would be for rash driving 10 years in case of hit and run, uh, plus fine. This 10 years can be reduced to 5 years when such person causing death by any rashness or negligence has informed police or nearby magistrate. If he informs, he might get lesser degree of punishment, that is 5 years plus fine. And in case of medical negligence, if any medical practitioner, he should be a registered medical practitioner here. And if such medical practitioner has caused death while carrying out his procedure, he shall be punished for 2 years of imprisonment plus fine. And rash or negligent act should be both immediate and necessary cause. It was not premeditated. It should be immediate. And these are the two case laws that I would urge you guys to refer. Balachandra Vaman Pathe versus State of Maharashtra, Ambalal D. Bhatt versus State of Gujarat. So I would urge you guys to just look upon these case laws. So when it comes to rashness, it is not a general rashness or negligence. It should be a criminal negligence or rashness that differs from fact to fact, and facts and circumstances would be really important while determining whether it is criminal negligence or an ordinary negligence. So criminal negligence would suffice. For medical treatment, while in case of when we talk about medical negligence, there is a test called Bolam test. So uh, this is the test uh, that is employed to make a person that is registered medical practitioner to make him liable. This test is employed. For example, if there is a disease, and for curing that disease, there are multiple treatment that is available, and doctor gives a medical practitioner gives a particular treatment and does not give the other one. Just because he has given that treatment and not the other, and uh, it has caused the death of another person, you can't just make the medical practitioner liable just because he has not provided other sort of treatment, right? So there are multiple treatments and the doctor has given one such treatment and it did not work eventually. and has caused death of a person, and therefore, in such case, you can't make the medical practitioner liable because there are multiple treatments, various treatment that is available. So this is a principle here. A man is not negligent merely because the body of his opinion would differ. Here, so just because the doctor has failed to prescribe other medicines does not make him liable when there are multiple treatments available. But definitely, civil liability might attract, not the criminal liability here. And Section 80 of BNS deals with dowry death. So in state of Himachal Pradesh versus Nikuram, dowry will be pronounced thrice by the judge itself. Dowry, dowry, dowry uh, simply means dowry before marriage or during marriage or post marriage also. So everything comes under dowry only. And when it comes to dowry death, has caused death of a woman, and death death of a woman has been caused due to burns or bodily injury or even otherwise. And a death of a woman should not be like normal death. Uh, it should be like other than normal circumstances. The death should have been caused, and she was subjected to cruelty soon before her death, right? So she was subjected to cruelty, and she dies within 7 years from the date of marriage. Only then she'll be attracted under this provision, dowry death, and she was soon before her death was subjected to cruelty. So this is a very important provision. It is generally a presumption that takes the upper hand on the whole provision itself. The presumption is that here now the burden to prove that she didn't die because of cruelty will be shifted upon the husband and his relatives. So the husband and his relatives must prove that she was not subject to cruelty, or her death has been caused only because of the cruelty that has been inflicted upon her by her husbands and relatives. So the presumption is really important. And Maya Devi versus State of Haryana. In this case, it was held that while convicting a person under this section, the judges should take note that whether there is close proximity between the cruelty and the death. There should be a proximate nexus between the cruelty that has been inflicted and the death that has been caused to that particular person. And a relevant case that I would suggest you guys to go through would be Parvati Devi versus State of Bihar. Section 107 of BNS deals with abetment of suicide of a child or insane person. This is just a norm, a simple section to read that whoever causes death of a person under age of 18 who is insane or intoxicated person, a death has been caused of these persons, and it is due to abatement, then such the abetter would be punished for 10 years of imprisonment and life imprisonment and fine. And section 108, beg your pardon, this is not plus, this is yeah, all three punishments can be given. Section 118 deals with abatement of suicide. So it is not for child or insane or intoxicated person. It is for normal person, yeah, which is dealt under section 118, 108. So it is a straightforward section, and the punishment would be 10 years of imprisonment plus fine. So suicide or attempt to suicide is no more an offense under BNS. That is a very important fact to note, except when stopping public servant and public servant is, yeah, an exercise of his duty, and he has warrants and stuff, and he's exercising his duty, and a person preventing uh, of his exercise of his duty by blackmailing him that he would be, I mean, preventing the public servant from doing his duty, blackmailing him like, I'll be dead if you don't do this, or if you do this. So such attempt to suicide will be a crime under this Bharatiya Nyaya Sanhita. Section 108 deals with force. So the definition of force is given under this provision 128. So a person is said to use force when it causes, changes, seizes the motion, not just motion, affecting other sense of feeling as well, by his own power. Is generally using his power to make any force, or is disposing any substance, and is also inducing any animal here, like uh, not tying the ropes or chains of dogs and just inducing the animal to kill someone. That could also be covered under this provision. Chandrasekhar Rao is the state of Bihar. That is a relevant case that I would urge you guys to refer for this provision. And section 129 deals with criminal force. So criminal force is an intentional use of force. Here only force has been defined, and it is not it the force has been defined, and there is no punishment attached to this, because this is just a definition of force. Simply a force would not constitute a crime, only criminal force would constitute a crime. Here there is an intentional use of force to any person to commit an offense or to cause injury, fear, or annoyance. Section 130 deals with assault. So assault is not about causing harm to any person, but just showing or providing a gesture that he or she may be subjected to some, uh, bodily injury. So even making such gestures would constitute an offense of assault. Whoever making any gesture or preparation with intention or knowledge that he or she going to cause an apprehension that a criminal force can be used against them. So here, a gesture that has been made upon a person that a criminal force is going to be used against you, that would constitute an assault. For example, shaking fist, like he's ready to beat him, and unloosing the muzzle of a dog, as I said. Just because you have a grudge upon a person, you're just unloosing your dog muzzle and uh, making the dog uh, to kill someone, and with stick, just showing that I will beat you. That would also constitute assault because a criminal force is being used here. Pointing a gun, and it will also constitute extortion because there is an um, uh, instant fear of death, right? Pointing gun is not an ordinary thing, so that would also constitute an assault. Section 26 clause 1 deals with wrongful restraint. So it is a straightforward section. We'll just read the provision here. Voluntarily obstructs, like to prevent a person moving to any direction. So uh, wrongful restraint and confinement might sound similar, but they both are two different things. And wrongful restraint is about a person has a right to move anywhere freely, but you're just restricting him to move freely to one particular direction. So a person has a right to move, but you're preventing him from moving. So that is wrongful restraint. So uh, uh, for constituting an offense of wrongful restraint, it is not about just a physical prohibition. Physical prohibition is not necessarily mere verbal prohibition would suffice. Like, if you do this, uh, you should not move here, else I would do something else. That is a verbal prohibition, right? So merely verbal prohibition would suffice. It is not necessary that you should make a physical prohibition, tying chains and stuff. Vijay Kumar Maki versus Srimati Rao. So that is a relevant case that I would suggest you guys to refer. And Section 127, Clause 1 deals with wrongful confinement. Here, whoever causes, restrain any person in any manner, prevents a person going beyond certain circumscribing limit. There is a circumscribing limit here. It is not about any direction, of course, any direction, but there is a circumscribing limit that is here in confinement. When we talk about confinement, the place is not unlimited, it is limited. Even within that limited thing, you're restricting. Like, there is a circle or there is a square uh, beyond which you cannot step into. So that is confining a person. So that is a circumscribing limit. That is a keyword here for wrongful confinement. And there are multiple provisions and their respective punishments that are provided here. Section 127, Clause 3 deals with wrongful confinement permission. Punishment. That is when a person is confined for wrongfully for 3 days plus is more than 3 days, then that person shall be liable for 2 years of imprisonment plus fine. And Section 127, Clause 4 deals with wrongful confinement when a person is being when a person has confined wrongfully another person for 10 days or more, then that person confining shall be punished for 3 years of imprisonment plus fine. And Section 127, Clause 5 deals with wrongful confinement in case there has been a wrongful confinement, but a writ of habeas corpus has been uh, filed in the court of law, and the court has issued a liberation writ to just release that person from confinement. And even after that, the person confined will doesn't liberate that person or release that person. He would just proceed him to be confined, and that scenario, the person shall be liable for 2 years plus additional punishment that will be given by the court. Section 127, Clause 6 deals with wrongful confinement in secret. Nobody knows that person is being confined. So it is a secret confinement. That too is wrongful, and the person confining wrongfully in a secret means shall be punished for 2 years of imprisonment plus additional punishment uh, given by the court. Section 127, Clause 7 deals with wrongful confinement to extort money or committing any illegal act. So, for the purpose of extortion, a wrongful confinement has been made. In such case, the convict shall be punished for 3 years of imprisonment plus fine. And Section 127, Clause 8 deals with wrongful confinement in order to extort confession or compel restoration of property. Here, wrongful confinement has been made to extort confession, and therefore the offender can be punished for 3 years of imprisonment and with fine. And that is all about offenses against uh, human body and offenses affecting human body. Beg your pardon. That is all about today's lecture. Thank you, guys.